Hello friends, welcome to Happy Institute YouTube channel. Happy Institute is one among the leading institutes imparting training in stenography. The institute in the last 35 years has helped hundreds of aspirants of government jobs in fulfilling their dreams. Students of this institute have secured top ranks in various All India competitive exams held by UPSC, SSC, DSSB, IBPS, and other recruitment agencies and are working in almost every department of Government of India, be it Ministry of External Affairs, Railway Board, Home Ministry, Election Commission of India, Income Tax Department, CBI, and other prestigious organizations like Supreme Court and High Court. We also publish happy speed dictations for developing speed with passages meticulously selected from latest topics with practical phrases and simpler outlines. This book has become the most prominent choice of almost every reputed institute, teacher, and student of stenography in a short span of time. The proof of its popularity is that in the last 3.5 years, more than 25,000 copies have been sold all over India. We have now launched a series of legal dictations to help aspirants who have to appear in skill test of Punjab and Haryana High Court on 27th February 2022. The dictation is released every day at 1 p.m. on Happy Institute YouTube channel. The students are requested to write and transcribe this dictation and compare with the original passage given in the description more than once if required. Please like and share every dictation that you write and subscribe to Happy Institute YouTube channel. Get ready for dictation, please. 5 seconds. Start. Similarly, aggrieved against not ordering immediate eviction of the tenant and framing of issues in both the petitions, the respondent or landlord also preferred two appeals before the rent authority. Therefore, the appellate authority considered 4 appeals, 2 filed by the petitioner or tenant and 2 filed by the respondent or landlord. The appellate authority dismissed the appeals filed by the petitioner with connected matters and held that the application for rejection of the eviction petitions had rightly been dismissed by the rent authority. In the appeal filed by the respondent or landlord, the appellate authority held that since the rent has not been paid by the tenant and the default continued even during the pendency of the proceedings before the rent authority, therefore the tenant was liable to be evicted for non-payment of rent. Hence, the appeals filed by the landlord were allowed. However, the matter was remanded to the rent authority to grant an opportunity to the petitioner or tenant to pay the up-to-date rent to the respondent or landlord, failing which the rent authority was directed to pass the eviction order without carrying out any further proceedings. It is against these four orders passed in two different eviction petitions that the present four petitions have been filed by the petitioner or tenant. It deserves mention here that it is not even disputed that the petitioner has not paid any rent after filing of the eviction petition before the rent authority. Before the appellate authority also, no rent was paid or deposited by the petitioner. Before this court also, the matter has been pending for about 2 years, but no rent has been paid or deposited by the petitioner. Hence, during the entire period of litigation, the petitioner has been occupying the premises without payment of any rent. Before proceeding further with the arguments, this court had asked the petitioner whether he was ready to pay the rent and its arrears to retain the premises. The counsel for the petitioner had sought time to get instructions in this regard. However, on the next date of hearing, the counsel for the petitioner submitted that he has the instructions to say that the petitioner is not in a position to pay any rent because the petitioner has gone bankrupt. These facts and the assertions by the petitioner itself with connected matters disentitle him to continue in possession of the premises in question for even a single minute, and the petitioner is liable to be evicted from the premises with immediate effect. However, since the petitioner has raised certain legal questions, therefore it is appropriate that this court considers the same and then decide the matter. Arguing the case, counsel for the petitioner or tenant has submitted that both the courts below have gone wrong in law in dismissing his application for rejection of the eviction petition filed by the landlord as not maintainable as per the mandate of section 22 of the Act. It is submitted by the counsel that the Act prescribes a mandatory condition of giving notice by the landlord to the tenant in the prescribed format as given in schedule to the Act.